Realtors, welcome to the Legal Podcast. I'm Byron King, Chief Legal Officer. Austin, introduce yourself, please.
Austin Small, attorney with SCR.
And we got some special guests today. I'll let you guys introduce yourselves, kind of give you your background. We've got two practicing attorneys. One is with a law firm, one's with a title insurance company, so we're excited to bring them here. And they also teach at USC School of Law. So, Bill, if you'd introduce yourself, give you a little bit of background, please.
Thank you, Byron. I'm Bill Higgins. I practice law here in Columbia with the Grable, Lanchey, and Vinzani law firm. Our practice firm-wide is very much real estate centric, as is mine. I do some other things, including lawyer ethics and some non-real estate transactional business, but I consider myself a real estate lawyer and have been doing so coming up now on my 40th year.
Super. Welcome. Thanks for joining us. Terry, introduce yourself. A little bit of background, please.
Terry Callan with Chicago Title Insurance Company. I thought I'd been doing it a long time. I'm coming on my 33rd year, so I'm catching up to you in the practice of law. You're fancy. You're a transactional lawyer. I think of myself as a dirt lawyer. I did mostly commercial real estate transactions in private practice, but I've been teaching at a law school, teaching the real estate transactions too, which is a residential real estate based course. I've been teaching that. This is my 14th year. So I get to keep up to date with all of those things for that class. And thanks for having us here to talk about what we're teaching some of our students.
What we wanted realtors to learn is how closing attorneys are kind of trained at this USC School of Law, South Carolina School of Law. So I guess looking at the thing, Bill, you teach real estate transactions one. What's kind of give a 30,000-foot view of that for the realtors, how you start training these new lawyers in real estate transactions.
Great. I'm happy to do so. And I too hear that this is Dave Whitener's class. And I quickly disclaim that I don't come near to Dave's reputation, but I do aspire to make it a practical course. And when I was asked to do it, that is to teach the real estate transactions one, I've now taught it for 8 years. I assumed they were going to give me some old syllabus and tell me how to do it, and they said, have at it. And so about the only parameters I was given was that my course was designed to cover the waterfront, and it would be the first real estate class after students had taken a property class. But back in the day, we took 2 full semesters of property as first-year students. They now only take 1 semester in first year. And because of the significance of digital property, the relative emphasis at the law school in the property class is not what it used to be on real estate. So my point is the students, my course is taken, you can take my course either as a second or third year, but obviously in order to do that, you've taken 1 semester of property, but it's not as real estate intensive as it used to be. The point of all that is I'm not sure that law students have in fact, I'm sure they don't have the first year grounding in traditional property principles that they used to. And so while I desire for my class to be practical and, again, to focus on transactions, I feel like and spend some time on some basic blocking and tackling things, deeds and warranties of title, for instance. But what I do is I construct my class, even though, I desire to cover the waterfront, it basically, the first quarter of the class is a contract class, a real estate contracts class. And I take 1 form that I use for a commercial transaction, and then I take, for the residential, I take the realtor's form. And we start, the very first assignment of the class is very simple. They're to review those 2 forms of contract. And then I make an introduction in the first class about that. And then literally we spend the second class of the semester literally walking through each provision of each of those contracts, the commercial contract and the residential contract. Then for the next 4 classes, and in fact the third class is a class devoted to thinking about brokers and commissions. And so we obviously in that third class focus on the relevant provisions in the contract that deal with brokers and commissions. From there, we still, for the next 3 classes, classes 4, 5, and 6, we dig into particular aspects of the contract. And again, what I'm trying to do at that point is say, okay, here's what the contractual language says, but why do you think it says that? And based on what it says, what do you think about this, depending on whether you're representing the buyer or the seller, or perhaps the broker? And so we try to start thinking initially, or even initially, not only about what the contract says, but why it says it, whether you would have an opinion about it as a lawyer, depending on who you represent. And then, again, sort of an overarching element of my practice is that largely in real estate transactions law, you're always called to be an advocate for your client's position, but relatively rarely are you called to be an adversary to the other side. You follow? It's transactions. A fundamental difference between transactions and litigation, for instance, is presumably both parties want the same result in transactional work. And so one of the things I explain to my students is it's all well and good to take a strident position on behalf of your client, but if it causes the transaction to fail, wonder whether you've accomplished anything. That's a lot in one thing. Let me say one more thing. After we sort of unpack this, hey, what really matters is what the contract says. And that's what I tell them. He said, you can make of it what you will, but the contract is going to be your governing, it's your roadmap for the transaction. After we get through that, again, with this idea of trying to be very practical, we then go through a series of classes dealing with the sorts of things that you'll be dealing with post-contract, pre-closing, all manner of due diligence, title work, surveys, easements, financing. We then spend 2 classes on closings, one on closings proper and one on what I sort of call post-closing, which is recording and disbursements. And then after that, we sort of fan out and cover a wider variety of topics. But the point is, it's very contract and closing centric.
Terry, you teach the second semester. They kind of take back to back, right? Real estate transactions too. Kind of give the realtors a feel of what you teach and what the students learn in your second real estate transactions too, please.
Well, we take what in the fundamentals that Bill has taught them very well, and Bill actually used the phrase, and I'll borrow it, we roll up our sleeves in real estate transactions too. We take all of that information, and I have them, for a particular closing scenario I have them go from drafting a contract all the way through to completing the full closing package. And I know that they've learned a lot about the contracts. They've reviewed the SCR 310 and they've reviewed the commercial contracts. So they've seen and gone through really, with a lot of information, gone through each of the sections of that contract. And part of what Bill was saying, the synthesis, realizing what it says, why it says it, and then how should they draft one? Because I feel like if they actually have to pick and choose after learning what each of those paragraphs mean in Bill's class, then they have to make the decision what's best for my client. And I tell them all the time what Bill said, you can draft a one-sided contract that is beautiful for your client and the seller would never sign it. And so one part of the scenario I give them is your clients really want to buy this house. And so I tell them there is a way, and understanding the provisions in that contract and what they mean, what the unintended consequences are, how one paragraph interacts with another one, that they have to draft it and craft what they believe is a contract that will be good for their client, will hit all of the requirements that are in the scenario, but also be likely, that the seller would like. The seller would be likely to be okay with. And we focus also, as part of that closing package, the closing attorney in the real world really wears 3 hats. I used to say 2, but it's really 3. You've got your attorney hat, and we have obligations under the rules of professional conduct, lots of obligations, but competence, communication, making sure that you're competent enough to know what the issues are, communicating those to your client so your client can make an informed decision about whether or not to purchase the property in this example. So you've got those obligations to your client. Then most closing attorneys are title insurance agents in South Carolina. And so you're also wearing a title insurance hat because you have contractual obligations to your title company as the agent to follow their underwriting and issue a title insurance policy, which, as we all know, in a conventional mortgage situation, all the lenders want to, title insurance. There's the title insurance waiver type thing that hasn't really gotten much ground, but pretty much Fannie Freddie, all the GSEs want to see title insurance. So make sure they understand their obligations there. And then the third hat is being as an approved attorney for a lender, because the only way you can close a transaction for a lender is to be approved by them. That's different than being on the TRID written provider list, but you actually have to be approved, and you have to follow the lender's closing instructions. And usually there's a closing protection letter issued when there's title insurance. The lender wants it, and that says you basically have to follow the lender's closing instruction. So the entire time they're in class crafting and reviewing the documents from contract to closing package, I'm having them think about all 3 of those hats and what they have to do to make sure they don't get disbarred, that they're following the rules of professional conduct, making sure that they stay licensed as an agent for that title company by not, ignoring underwriting and creating and causing claims, and then also following what the lender says, because under the closing protection letter, if the closing attorney doesn't follow the instructions, the lender can immediately file a claim under that closing protection letter, whereas a lender has to wait until there's a default on the mortgage to be able to file a claim under the title policy. So following the rules is very important in what closing attorneys have to do in the real world, but also, the students for their exam, make sure that they understand how all of these interact. And to piggyback on what you were saying, that about the synthesis of that and really understanding how these documents interact, I feel like making them draft each of these documents themselves, it makes it stick in their mind, if nothing else. They'll go, wait a minute, I think I remember maybe this clause I wasn't sure about, or, I remember, I think, because this property was on the lake and it, on the waterfront, but didn't abut a public roadway that it has maybe legal access, but not vehicular. So just a couple of things as we're going through when they're actually having to draft the documents. Hopefully, that's something they can build on with experience, but, it's a good starting point that they will remember having drafted it themselves. But I still feel like I know this was my situation. In law school, if you were doing an essay, you tried to write as much as you could to hit as many points, salient points as possible, so that your points would add up and maybe you'd get, a better grade. And I don't know how they do the bar exam anymore, because it's been a long time. It's changed a lot since we took it. But it used to be that it was all, the written essay part. We had 2 days of it, and you wrote every single thing you could think of. And they would grade until they hit 70. They give you points, and then it's 70, and then you've passed that topic. And so I tell my students, the real world is not a bar exam. The real world is not getting a grade on an essay in law school, especially with a contract. If you throw everything in but the kitchen sink, if you do it in the contract or the title commitment, if you do that, it's more likely to cause problems than fix anything. don't, the more you put in, the more there's an unintended consequence that it's going to conflict with another provision. So that's, I think, the hardest thing for students is transitioning out of that. I'll just keep adding things until I can get a grade, as opposed to really asking and figuring out, is this necessary? What is my end result? What am I trying to accomplish? And will this truly hurt, hinder, or be no big deal to my client in making those decisions?
Super. Yeah, I like the equilibrium between the buyer and the seller and being succinct. Austin's our staff liaison to the Forms Committee. Also kind of talk about Forms Committee philosophy, being succinct, trying to meet in the middle, and the new forms that are coming out that I think realtors will be excited about.
Yes, I mean, that's sort of the goal we have on the Forms Committee, is say that we don't want to make a form that's buyer friendly. We don't want to make a form that's seller friendly. We want to make a form that's transaction friendly. We always say buyers and sellers who want to make a deal will make a deal. The ones who don't, won't. It doesn't matter what the contract says. We also try to make sure that we don't have a form that covers all the issues that the people on the coast want and has nothing that people in the upstate want, or covers only stuff in the upstate and nothing on the coast. It's a statewide form, so it needs to be done for everybody, but it is a standard form, so there's not every transaction is going to work for. If you've got something that's really complex, that's not where a standard form may apply. That's where you look at the standard form, have your attorney look at it, and if it doesn't match up, then have an attorney draft a new one for you, or draft addendums, or whatever it may be.
So on the next part of our thing, we're talking about contracts and the closing. Bill and Terry, can we talk about how what's in the contract impacts how it's closed and shown in the disbursement statement?
Sure. Well, I think to Austin's point, and it's a very valid point, particularly for somebody who does a lot of commercial transactions now, and we go on and on and on in commercial contracts about how we're going to manage things. And a good example is title. If you go to a typical commercial transaction, title and survey provision, it has all manner about how we're going to deal with it and all this. The residential contract pretty much assumes there's not going to be a title problem. What it says is the seller's got to give good and marketable title, but it doesn't really deal with what happens if that's not the case. And so the point I want to make about that is I do think that's the right compromise for the residential form. But I would suggest that in a sense it puts a bit of an inordinate burden, appropriately so, but nevertheless inordinate, on the closing attorney who's also going to be the title insurance agent, because that lawyer, in his or her capacity, both as a closing attorney and the title agent, is having to make certain determinations. And in many cases, I don't know what y'all are seeing in the marketplace. I was told recently that we are seeing more and more sellers being separately represented by counsel. But assuming that we still have a fair number of situations where the closing attorney is either engaged as a full engagement with the buyer-borrower and either a partial scope engagement with the seller, or even if not, still owes duties to the seller, it can be sort of tricky. And so, again, if you're on the realtor side of a transaction and the lawyer discloses, hey, we've got we got to postpone the closing because we got a title problem, trust me, that's the last thing that lawyer wanted to tell you, okay? They do not want to tell you that. They want to tell you we got to roll. But anyway, that's an example that I see where the contract doesn't, it just basically assumes title is going to be good, and everybody needs to understand then that's the lawyer's responsibility, both as the closing attorney and as the title agent, to make that work.
That's a good point, because even though the contract says, hey, you need to talk to a lawyer ASAP in the transaction before you sign, most residential folks don't. If you're talking to a realtor, say I'm a realtor, and you're saying, hey, Byron, here's some questions you could ask that seller to try to find out if there's some title problems. What could you could ask for, like probate or tax sales? What are some things a realtor could look for?
I think probate and tax sales would be obvious, but relatively speaking unusual as a percentage. So probably if I were talking to a realtor and saying, hey, you're the listing agent, what is it, what information you want to get from the seller? When did you buy it? I hate to put it this way, who do you think owns it? Which what I mean by that is husband and wife may have a different view of, and may have a different recollection. It's pretty important, or relatively speaking, early on, are you in a subdivision with comprehensive restrictions, or are you in an older part of town? The geography, believe it or not, matters for title purposes, because, for instance, if you're in one of the newer subdivisions, again with what I'm calling a comprehensive set of HOAs, that's one type of title to deal with, whereas if you're in Wales Garden in Columbia, it's a much different situation. So probably when did you buy it, how do you think title is held, and then of course might as well go ahead and get mortgage information.
And then Terry, same question. Say Austin and I are a team, we're listing, and you see all these problems at title insurer. What, if you're giving us advice, hey, Austin, Byron, what should we ask our sellers to try to detect some of these problems before they become big problems at the closing table?
My number one thing is, how do you get there? What's the access? If it's in a subdivision, and it's got a subdivision plat with the roads, most likely the covenants or restrictions have given a non-exclusive easement over the roads. So you're less worried about access in that situation. When they're outside of a subdivision, sometimes if the property does not abut a public roadway, then that creates the potential that there may be an easement that gives access. And I could talk about a bar exam. I could write a bar exam question that would have people in tears about what is exactly a public road. It used to be if it was publicly maintained. And then when the bubble burst in 2008 and the mortgage crisis, a lot of counties said, okay, how can we lower expenditures? And if there was a road that wasn't dedicated to them, publicly dedicated, but they were maintaining it, some counties chose not to maintain those anymore. So it's kind of a question, is it public, is it not? There's a great, SCDOT has their Street Finder. You can just Google SCDOT Street Finder and put in the name of a road, and it will tell you, according to their records, if they maintain it per their records, and if they do, it identifies that, or if it says local, then they assume it's a municipality or a county, someone other than them is maintaining it. And then you can kind of drill down a little more easily to try to figure out, is it really a public road or not? And why do we care? This is why. If access is through an easement, then you have to search not only what the Servian estate, so not only the property that you're listing, but also the property that is giving the easement, that is burdened, the one you have to drive over to get to the property you've listed. So you have to search that property as well. So that's 2 title searches. And you have to search that to make sure that the easement is in fact valid. I've seen more than once where when the easement was given, the person didn't own the property anymore. They subdivided it, gave it out to their kids, and then recorded an easement that said it, but they didn't own it anymore at the time that the easement document was recorded. So that's why there are 2 searches. And the reason it's important for the selling agent, the listing agent, to know that is they can pass that information along so that the attorney knows right in the beginning, we may be looking at 2 searches, because if you get your title search and then you find out when you review it that access appears to be through an easement because it doesn't abut a public roadway, then you order another search, then there's potential that it could delay the closing. And of course, nobody wants that. So that would be, that's so simple. Oftentimes, the counties often will have lists of what their public roads are. So that's a good one. Anything that you know about that particular, especially if it's in a subdivision, because, realtors, they're the ones that are, in the trenches. They know these properties really well in terms of what's allowed in this subdivision versus that one. And, everybody loves chickens now. and there are plenty of covenants and restrictions that don't allow chickens. And then short-term rentals. That's the bigger issue that we're seeing, where we've had the South Carolina Vacation Rental Act since 2002, 2012, 2002, I think. And so it's been around for a while, and it's got a lot of provisions about notices that have to be given to property managers if they manage it, notices that have to be given before you even sign the contract. So that's another thing. If you know that it's out there, there are certain notices that have to be given before the contract is ratified. There are even provisions in that act that say that up to, I believe it's 90 days after the deed is recorded, not closing, but whenever that deed gets recorded, whatever short-term rental, Airbnb deals that they had, whatever they've got out there, those people that rented it for up to 90 days after the deed is recorded can go, knock, knock, knock. Hey, I booked a week here, so I'm here with my whole family and my dogs, and we need to come live in your house. And all of that should have been disclosed in the new disclosure. They've had those provisions, the last few versions of that when they added the short-term rentals. That should have been disclosed. But closing attorneys, and I say this all the time, I say closing attorneys, put in your engagement letter, say you would have gotten a disclosure. There are a few exemptions out there when disclosures aren't required, but ask your client to give it to you, because there's so much information about solar panels, that have a huge impact. So that'd be another thing. If it's got solar panels, you make sure the closing attorney knows that from the get-go, because of doing a UCC search. And there are just so many things, but the short-term rentals especially, that's so impactful. And knowing that, because there can be violations, the client can assume that because the current seller has it as an Airbnb, that they can do it as well. But a lot of HOAs have amended their restrictions so that they're not allowed, maybe never allowed them, and somebody went rogue, the seller was rogue. But who better than the listing agent to know a lot of this information? And if the closing attorney knows that up front, they can look at a potential that there's already a violation of the covenants and restrictions, where there are any notices. The sooner they catch that, the better it is to smooth it out, either ask for a variance from the HOA, or, the sky's not falling, but the sooner the closing attorney knows that, the better chance to smooth it out so that the closing's not delayed.
Yeah, definitely, because we talked about our standard contracts. There's a bunch of standard contracts. Columbia's got one, the state's got one, Hilton Head's got a bunch, lawyers draft them. But ours, the state form, is about a sale, like a complete sale, not with rentals. So good point. Anytime there's any kind of leasing, solar panel, short-term, long-term, vacation rentals, the sooner the listing broker can take the seller client to their lawyer to research that and get all those things taken care of that Terry was talking about. Excellent. I'm looking through our questions here. Terry, what's in this is question number 2. We're going through how in the contract impacts how it's closed and shown in the disbursement statement. Kind of your side. We've asked Bill that question. Same question to you, please.
Well, for one things I mentioned was just the way they're disclosed. It has to meet real life, and even title insurance, the federal disclosure wants it shown a certain way. South Carolina has filed rates for the title insurance, and all insurance filed rates. So you have to have a separate settlement statement, not because the lawyer wants to have 2 documents. They would love it to just have one disclosure, but because they must disclose it to stay right with the Supreme Court, showing exactly what the title insurance for the owners and the loan policy, what they actually are in real life in South Carolina per the file rates, which is different than the way the feds want it on their disclosure. They want it shown a completely different way. Same for commissions. One of the big things I'd say in the way the attorney is figuring out the amounts, especially when there's a rental, is the prorations part. And a lot of the various realtor-type contracts, they use at closing in one paragraph, through closing in another paragraph, and I'm blanking on the third. They
Sometimes it's to the date of closing.
yes, to the date of closing or to the closing date, and then at and through. I think that's it. To, at, and through. And so the biggest question we get is, what is the difference? Is it meaning that is that a intending to have it differently, or are they just using different terms that they believe mean the exact same thing? And because it matters. I know I sold a long-term rental piece of property, and of course at 6%. And the way the proration went, before I signed the contract, I looked to see I've got my income for rental, and then I per diem, for proration, and then for the days I owned it in that month, and then I would have my taxes for those days, and which was more beneficial to me. And so that's the way I was looking at it as a seller. But bottom line, no matter who you're representing, just making it I tell them the best I think you can do is make it uniform. Yes, because everybody wants to know who pays for the closing day. That's all they want to know. Who gets the rent through that day, who has to pay the taxes through that day. So I just told my students, for the exam purposes, just make it the same. Just pick a day, buy or sell, or somebody gets closing day, pick it, stick with it, and for the exam purposes, that works.
Well, and it's another example I would submit to you where, the residential closing attorney may have to exercise some discretion that he or she wouldn't have to exercise typically in the commercial, because in the commercial setting, what we would do, because we're going on and on and on about things, is we would have a sentence that says something to the effect, for the avoidance of doubt, for all purposes under this section, the proration section, the seller shall be deemed the owner of the property through the closing date.
Yes.
Or
Yeah.
purchaser, whichever. And so, so we've just put in a single sentence that's what we're going to do. But I think the key is uniformity. It doesn't seem to me to make much sense. I guess you could draft it this way if you wanted to. It doesn't make much sense that for some purposes the closing date is owned by the seller and other purposes the purchaser. So I think internal consistency on that's important.
And then, Bill, because you do a lot of commercial, say Austin and I are brokers, we're real estate brokers, and we're kind of new to the commercial world. We do residential a lot, but we're going to handle some sort of a commercial deal. What would be some recommendation? Should we come to you first to help us? Because we have a standard form. It's just a cookie cutter commercial form. What would be your preference? Would you like us to come to you ASAP and try to get you involved from the get-go?
Yeah, I think so. And that's not to say that the cookie cutter form wouldn't work, depending on the deal. But I think having an experienced lawyer, experienced commercial real estate lawyer, look at the form contract and say, these 7 things are fine, but these 3 things, if we don't make adjustments to them, it's going to create a bit of a problem. And then I do think if you're a realtor who typically does residential and have moved over, either intending to make a move permanently or just making a temporary move, probably talking to a lawyer with experience early on just to get a sense that the transactions really are very different. And I can't tell you exactly how, right? But they are very different. And so yes, I would encourage a broker who's venturing over into the commercial side to reach out and engage, maybe engage in a conversation with somebody who has some experience.
Yeah, because I'll go ahead, Terry.
Now, I was going to say, I venture to say the difference, because you're like, I'm not quite sure exactly what it might be. Intended use is what is the biggest thing I found when I was doing commercial work. If it's a residential real estate transaction, they're probably going to use it as a house. That's that's what we're assuming. Generally, the lender requires that they say if it's going to be their primary residence. In commercial, you have no idea. It could be a residential property that they want to use as an office. So you've got all of the zoning implications, and which is another reason why it's a great idea to engage the attorney sooner rather than later to see that if it's even possible. We had a situation once where there was a vacant piece of land near a dairy, and The dairy owned all the land, and someone came along, and it seemed like a really easy. They were going to put a dry cleaning facility where they actually did the dry cleaning, and it's all this rural land and acreage, and how difficult could it be? The dairy was completely happy with it; everything was great, but they were like, oh, but we're going to have to tap in because dry cleaning plants can't be on septic. They have to tap in, and there are all these regulations for their chemicals. And even the dairy was like, that's great, no problem, tap in. They had everything worked out for the construction that would be needed. And then they found out the only way to tap in would block the only road that goes into the dairy. And they couldn't, dairy, those trucks are going day and night. So it's not like they could just say, we'll only do the construction at this time. So, the whole deal, it got almost up to the very end of due diligence before someone went, wait a minute, everyone's agreeing to do it, but practically, can we accomplish this and make everyone happy? And, there wasn't a way to do it. So the sooner you find out some of those things and talk with the attorney about the implications, like if it couldn't be zoned as a dry cleaner or some of those, the sooner you have that discussion, the better I think it can work out. And especially if there's a need for a variance or something so that it doesn't have to, make the whole deal fall apart.
Yeah, great point, because commercial, like you just hit the nail on the head, it could be for somebody might be living there as a tenant, or it could be retail or office or factories or dairies or a dry cleaner. Excellent points. Kind of our questions we go through here. We're talking about how title is held. What are kind of things that you guys talk about when you're drafting deeds in your classes? What are some parameters that you guys stress in your classes?
If you don't mind, we'll take this first because Terry's going to want to correct me. Okay. And what I do in the law school class is point out that we have a statutory form of deed in South Carolina, and that statutory form of deed defaults to a tenancy in common, and so that's the statutory default. Joint tenancies with rights of survivorship are also a statutory creature in South Carolina, and because of the way the statute was amended, in my view recently, it's not all that recent, but since I've been practicing law, there are some implications of the joint tenancies with rights of survivorship that I think people need to understand. So I tell my students, don't get cute. Either use a tenancy in common or use a joint tenancy with rights of survivorship, but understand if you do that, what the implications are per the statute. And for instance, we have other ways to hold title that I tell people turn and run the other way. You either be tenants in common. Now, of course, it assumes more than one. It's easy enough if it's one person. And let me say this, typically in the residential area, if it's a single family residence, we're talking about individuals. In my business, we're typically vesting title in an LLC, but assume that it's individuals, stick with tenancy in common or joint tenants with rights of survivorship.
I don't disagree with that. I would say don't put it in the contract. Don't say they'll hold it a certain way. Don't say that they're going to hold it in this name or that name, because then you've got to have an addendum if something changes. The biggest thing I would say about deciding whether or not to have it as survivor, any kind of survivorship, joint tenancy, is how is that going to impact their estate plan? Has the listing agent, of course the listing agent shouldn't be asking, or the buyer's agent, who's having that conversation? Probably no one with their client. Oh, so do you have an estate plan? How have you set it up to go into a trust? Do you have a testamentary trust set up? Do you already have trusts? And if something in the contract says that they're going to hold it with some type of survivorship, it could obliterate their, very expensive, well planned out estate plan. So that's really something that I explain and talk to my students about, that even something that simple, where they go, really, do you have to make this complicated? Can't you just say in residential, it should be this? But, no, there's so many unintended consequences and tentacles coming off of the simplest question. And I even tell them on the contracts, I was like, I know you're going to think you're clever. You're going to put in a residential contract. You're going to say, Bob Smith and Sue Smith, they're successors and assigns, and think that you're being, very lawyerly in the drafting of your contract that you've put that. I said, but you have, unless something in your instructions in real life or on your exam tell you that your client wants to assign this contract, why are you going to introduce that element that the seller may not want? I mean, I know of situations where they put in that, or assigns in the contract, knowing that this property was going to be used as a dog boarding kennel, and it was where the seller was going to had subdivided the property, and they had the, I believe, the frontage, and then they were selling the back piece, and having a bunch of barking dogs was going to make a difference. But the way the contract was written, they thought they were selling it to just some nice individual, and it said assigned, so they assigned the contract to, Bob's Loud Dogs LLC or whatever it was, and the seller was very upset about that. So even some of those implications. And the last thing I'll say is, if a client tells you, I'm going to buy it in my name and then put it into some type of entity, it used to be that the only thing we would talk about or worry about is, that might trigger a due on sale clause in your mortgage, or it might, and then a tougher worry was mortgage fraud. If you've told your lender that you're going to live in it as your residence and you're really not, and you want to put it in an LLC to limit your liability somehow, if someone says that's what they want to do, there are additional impacts now that we have the assessable transfer of interest. There are only certain exemptions that the moment a deed is recorded and the county sees what's happened, that can trigger an assessable transfer of interest, which, depending on what the situation is, could grossly impact their the tax value on it. And it depends on the situation. There are just so many aspects now, and in commercial, if it's commercial, it can mess with that 25% cap, depending on what type of entity you convey it to. So if any residential or commercial, if the client says to their listing agent, or the buyer says to their agent, hey, I'm gonna buy it in my name, but then I'm gonna do something else, they should also probably talk to their attorney and their tax advisor about what the possible implications are.
Excellent. And then related to the deed, the contract talks about marketable title, but from title insurance in your classes, when you talk about marketable title versus insurable title, what do you tell your students?
I'll do insurable. It's easy. We can make it insurable. As a title company, we're in the risk business, and we can decide that we'll take on the business risk to insure over an issue. But title insurance never makes title marketable. We can make it insurable, but not marketable. And I'll let him talk, if you like, about marketability. But the biggest thing I'd worry about as an agent, if it's only insurable title, when your client goes to sell the property, your buyer client's buying it, and they've got insurable title, when they go to sell it and they use the SCR 310 that says marketable, they may not have fixed it. A lot of times they don't. They close and never think about it again. They sign as seller a marketable title, and then that's awful for that selling listing agent, because they assume everything's good and that they've got marketable title, and that seller knew or should have known that it wasn't.
Yeah, I will say this. I think that is a relatively small percentage problem.
True.
Okay? Of course, it only takes 1% if it's your transaction, right? And it becomes a 100% problem. But I do think that's important to understand, and particularly in Terry's context. If your seller in a residential transaction has purchased the property at whatever point based on insurability rather than marketability. In other words, if they got comfortable through their title insurance, whoever will handle it for them, I can assure you they have forgotten that what they got was insurable title and not marketable title. And so they're not going to think about that nuance. And I honestly, I'd love to I don't think there's a fix for that. It's just the reality is if you take title that was otherwise not marketable because you are able to have a title insurance company insure over it, around it, or in some cases just plain insure it, it could be a problem. I will say this. I think that on a percentage basis is relatively rare. But let me ask you a question more directly since you asked it. I spent a fair amount of time, only one class, on making sure the students understand the difference between marketable and insurable title. And I invariably ask it on the exam.
Yeah, so if you're a student watching that for the exam, this is excellent. We're going to have to do another podcast. We're getting short on time. Austin, what are some issues on the hotline from title insurance? Well, you worked on like the NTRAPs, the 40-year marketing agreements. What question, Terry, can you kind of talk about NTRAPs, the 40-year marketing agreement? Austin, first of all, tell them what the government did to fix the problem.
Yeah, so last year the S-881 was passed in the law unanimously by both bodies that did sort of two things for the long-term marketing agreements. It ruled that anyone that was any of those agreements that are already on the record were invalid, and it said anyone going forward were invalid. So if they were filed, and I had folks say, well, hey, this was filed, this was already on the books, or anything that existed on the day the bill was signed was invalid because at that point, and anything going forward is invalid. So long as it ran with the land, it encumbered, and it didn't have signability. But there's a few exceptions for obvious things like power easements, water easements that you would want to run longer. But if it's something where you're trying to encumber the land and you're trying to lock somebody in, that those are now invalid. We are still getting calls of people saying that we are getting calls of those trying to be enforced. We've just said, hey, let the closing attorney know. And also under statute, the Attorney General's office has jurisdiction on that.
Terry, from your title insurance perspective, when these issues come up with your title people out there trying to close, what discussions are you having?
Well, I'll say in Florida, and especially in Florida, there were a lot of challenges. One of the big companies the company that shall not be named, but the big one that everyone has heard about, there was both a bankruptcy action and then a regular civil court action in Florida where they challenged the retroactive nature of the statutes, just like ours, that said even though that they've already recorded it, that the landowner already received compensation. They have challenged in every single lawsuit, every step of the way, the retroactive nature of it. In Florida, they just flat out shut it down. But reading the brief in the Florida case, when it talks about retroactive legislation and how, what the issues are with that and what the law is, and they're also dealing with it in the bankruptcy court, it's an interesting question. That's another bar exam question that, we could go on for days about just that aspect. But South Carolina is also just saying that it's invalid. North Carolina also, they have an injunctive order. Florida does as well. North Carolina, they're requiring the company to go in and actually record the cancellation. Our statute says that that's not required, that they're just, void on their face. And the idea is, unconscionability and, against public policy, that they're so unconscionable that they could not be enforced. So from a title insurance standpoint, we are, until a company wins a lawsuit and shows us differently, because we all have to go by whatever the courts ultimately say. As it stands now, we don't require a cancellation of it. We follow the legislation and recognize what it says. It says it's void on its face. I looked to try to see and find if there were any, if any progress had been made on the retroactive nature in any cases filed in South Carolina, and didn't see that there had been any movement on that. But they they're definitely fighting it in North Carolina and Florida and some other jurisdictions close to us.
Yeah, we'll definitely have you back. Any kind of closing thoughts from Bill, Terry?
Just thank you. Thank you for the opportunity.
Absolutely.
Thanks for coming. Thanks, Realtors. See you next time.